Judicial activism doesn't mean the same thing to everyone. I think a common observation people make about the term judicial activism is it's something you say about a decision you don't like. But part of my work has been to excavate the political history of judicial activism. My recent work has focused on both contemporary dynamics of political activism and historical analogs. And in 2015, the United States Supreme Court decided the Obergefell case, where they recognized a fundamental right of same-sex couples to marry. And in the dissent to that case, the Chief Justice criticized the majority for judicial activism. And he not only did that at some length, but he compared the Obergefell decision on marriage to a very famous decision at the early part of the 20th century called the Lochner versus New York. And that inspired me to look at how the political attacks on the courts as activists were the same or different in the two different eras, and I came up with some interesting findings. Number one, the political parties today are much more polarized than they were at the turn of the century and the time of Lochner. And by that I mean they're more internally, ideologically coherent, and they're further away from each other in terms of their attitudes. At the time of Lochner, the Republican Party was in fact quite divided. And the principal source of attacks on the courts came not from Republicans or Democrats, but from a third party, the Progressive Party. Whereas today, attacks on the courts as activists has been a mainstay of Republican Party politics since the time of Richard Nixon. And the Republican Party is very unified in its attacks on courts as activists. A second difference relates to the stridency of the attacks. The attacks, at least to the extent that Republicans and Democrats in the earlier period criticized the courts, much more muted, much more respectful, much more tentative. These days, particularly the Republican Party, since the time of Nixon, has included very strident, increasingly bitter attacks in its presidential platforms on the courts as activists. And then just a third difference between them relates to the expanded scope of the conflict over judicial activism. It was a relatively limited conflict back in the early time, among other reasons because Senate confirmation hearings were nothing like the show they are today. Supreme Court nominations are a major extravaganza and an opportunity for the parties to battle each other about the role of the court. In contemporary times, occasionally you'll have Democratic senators in confirmation hearings talk about judicial activism, and there they mean they're unhappy with Supreme Court decisions striking down part of the Voting Rights Act, striking down campaign finance regulation. But by and large, it's been a staple of Republican Party attacks, starting at the time of the Warren Court, escalating in rhetoric. And I think when you step back and look at it, what all of this means is that the court has become much more politicized and much more a part of political debates than it once was. It's a regular issue with constituencies and interest groups on both sides of it, and I think that affects the context in which the Supreme Court works.